So I'm going to go ahead and introduce Dana Barton, she's from County Counsel, and she's going to be doing the first presentation. So all yours, Dana.
Okay, thank you, Nicole. Well, good morning, everyone, and thank you for joining us this morning for this special districts training. And today I'll be going over both the Brown Act, which is the Open and Public Meetings Law in California, and I'll also go over a conflict of interest with you as well in a separate presentation. And so right now I'm going to go over the Ralph M. Brown Act, and that's found at Government Code 54950. And Nicole, you can move to the next slide. So open public meetings are protected under the Government Code, and the purpose of the Brown Act is to promote transparency and public participation in local government decision making. And so I've put this quote up here, which comes out of a portion of the Brown Act, stating that the people, in delegating their authority to the decision makers here, and all of you, I'm assuming, are probably board members of special districts or hold a senior staff level position. In delegating the authority, the people do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. And that really goes to the desire of the people to have all decision making transparent, and that the people insist upon remaining informed so that they may retain control over the instruments they created, meaning your agencies. And so, Nicole, you can move to the next slide. All meetings of legislative bodies of a local agency shall be open and public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency unless there's some exceptions that apply, and I'll go over that today. But the act applies to legislative bodies, meaning your boards. Special districts are legislative bodies that make local decisions, and you're either elected or appointed into your positions. And therefore, if you're seated in one of those positions and you act as a board, you must conduct your business only at public meetings where the public can attend, where the public can consider items of business, and you can only consider things that are listed on your agendas. And all meetings shall be open to the public, and all persons shall be permitted to attend any meeting. And that's really important. And we'll go on to the next slide to further explain. The act governs any legislative body, any governing body of any local agency, in other words, the Board of Supervisors, Board of Directors, City Council, your special district boards, any commissions, any committees, or boards or other bodies created by another legislative body. So for example, the Board of Supervisors has the authority to put together advisory commissions or committees or so forth. And local special districts can, put together advisory committees as well. And so the Brown Act also applies to those advisory committees. Nicole, you can move on to the next slide. The Brown Act has 3 different types of meetings that are governed by the Act. And those are regular meetings, which you all are probably familiar with, and then special meetings. Those are meetings where the body needs to meet outside of its regularly scheduled meeting periods. And then there's sometimes emergency meetings that will come up where the board needs to meet to make decisions or discuss items of an emergency nature where there's a shorter time period for notice. Nicole, you can move to the next slide. And so what is a meeting? It's any congregation of a majority of the members of the legislative body at the same time and location to hear, discuss, deliberate, or take action on any item that is within the subject matter jurisdiction of the legislative body. Further, members shall not use a series of communications, direct or indirect, to discuss, deliberate, or take action on any item of business that's within the subject matter jurisdiction of the legislative body. And so I'm going to talk about this a little bit more in detail right now. So a legislative body can only act when they meet and make decisions that are placed on the agenda together. Special district board members do need to be very careful when they're communicating outside of that meeting setting. And so examples of that is when an individual board member contacts or has conversations with other board members or another person outside of those meetings. You need to be really careful that that can be considered or turn into a serial meeting, or there's a common term called a daisy chain. And that's where one member may call another member and possibly talk about something that's within the subject matter jurisdiction of your district. And then that member moves on to call or chat with a third member. And that would be a situation where that would create a serial meeting. And that's discouraged and that's not allowed. And so you do have to be really careful when you're talking about subject matter of the legislative body outside of a defined meeting. Okay, Nicole, you can move on. Okay, so we'll get into, what is a serial meeting? And serial meetings are not allowed. And serial meetings can happen when you are emailing each other. You definitely don't want to hit reply all, because that would then create the serial meeting. Or if all of the board members are on that email, or if you're texting each other and creating a text chain serial meeting. Those are, you want to avoid all types of communication in that regard. And then I think I just kind of went over the hub and spoke, where one person talks to another person, and then that person then talks to another board member, and so forth. And so you don't want to do any of those things. You do not want to talk to each other about agency business really outside the meetings with a majority of the members. Sometimes there's purely social or ceremonial occasions where there may be a quorum of the members that are attending a wedding or a local community event. That's okay, but you do not want to talk about agency business at those events. You want to be very careful. You don't want to talk to each other and having any improper discussions, and you don't want to give the public the perception that you're talking about that. So you may not want to, all sit together at the same table, or, huddle together at any of those social events, because you want to avoid the perception of creating a serial meeting or a hub and spoke type event. Okay, we can move to the next slide. There are exceptions to the meeting requirements where you can have individual communication. And as I said, there's, in addition to the social events, sometimes board members attend conferences on matters of general interest. There's community events organized by the local agency that you can attend. And so those types of events, you would want to, not talk about agency business at those events, and just be very careful when attending events that you're allowed to attend as a group, but you don't want to create a meeting setting. So, Nicole, we can move on to the next slide. There's also formal exceptions to the open meeting rules where you're at a regular, special, or emergency meeting and you go into closed session. And so closed session is a statutory exception to the Brown Act, where the legislative body has special subject matters that are statutorily allowed to discuss. And typically that's going to be appointment of an employee, a public employee performance evaluation, a public employee disciplinary matter such as dismissal or release. It could be that there is existing litigation preparing to file a lawsuit, or the district might have an exposure to a lawsuit. And there's also, which is not listed on the screen here, limited reasons to discuss real estate transactions. And that would be really limited to discussing the purchase price for a property or the sale of a property. You can go into closed session for those reasons. When you go into closed session, you're going to want to list that on your agenda, and you're going to want to list the specific statutory exception. Each one of the exceptions that you see up here has a statute that supports that, and you would list that. And then you would always want to report out any decision that was made. And we can move on to the next slide. So every meeting you have to have an agenda, and it must be posted for regular meetings at least 72 hours before the meeting. The agenda must be freely accessible to the members of the public, and the agenda must contain the time and place of the meeting and description of all items to be discussed or transacted. If you have a website, you must post your agenda on the website as well, and we'll go over that in a little bit more detail in a minute. Special meetings, you must post your notice at least 24 hours prior to the meeting, and again, it must be freely accessible to the public and provided to requested media outlets. So sometimes you'll have a news organization or local newspaper or radio station that has made arrangements with the district to get notice of any special meetings that the district may have throughout the year. And so if you have such a media outlet that's pre-requested special meeting notice, you're going to want to send that out as well at that time. And again, the notice must contain the time and place of the meeting and a description of all the items to be discussed or transacted. And then emergency meetings do sometimes come up, and notice must be provided by telephone to the requested media outlets at least 1 hour prior to the meeting, and it's waived if there is no television or telephone service during the emergency. We can move on to the next slide. Thank you. If an agency has a website, you must post your agenda on the website 72 hours before the meeting for the regular meetings. We can move on. All agendas have to have a public comment period, and every agenda item the public must be able to comment on that. So the public meeting shall be the public shall be provided an opportunity to address the legislative body on any item of interest to the public before the meeting, before or during the legislative body's consideration of that item that's within the subject matter jurisdiction of the legislative body. So the items that you have on your agenda, you need to allow the public to be able to comment on those items. Special meetings, the public shall be provided an opportunity to address the legislative body concerning any item that's been described in the notice for the meeting before or during consideration of that item as well. A local agency shall not prohibit public criticism of the policies, procedures, programs, or services of the agency or the acts or omissions of the legislative body. So you need to make public comment period available for any type of criticism of anything that you're doing, in addition to praise. We can move on to the next slide. So sometimes a discussion will sway, or sometimes something will come up in a public comment period where the public is bringing something up that's not on the agenda, and questions can be asked by the board, like clarification, and so this is an exception to discussing non-agenda items when the public brings up something that's not on the agenda at the public comment period. The board can't make a decision on that, but they can ask clarification questions to learn more, and then possibly that could be put on the next agenda. We can move on to the next one. So the legislative body member or staff person may briefly respond to questions or comments by the public that are not on the agenda. A member or staff person may also ask a question for clarification or make a brief announcement or a brief report on his or her own activities, and may provide a reference to staff or elsewhere for factual information, request staff to report back at a later meeting on any matter, or direct a matter to be placed on a future agenda, just as I had said. And there may be an emergency situation, and there's specific requirements requiring a 2/3 vote to take action on any kind of emergency situation. And if that comes up, we're not going to go into detail about that today, but if there's something like that that does come up, or if you want to learn more about that, I'm available. You can call me directly if there's anything that you need to discuss about that. So violations of the Brown Act, there can be consequences to violations of the Brown Act, and they can be criminal or civil. And those are handled by the district attorney or any private person that's interested. And they may request a competent jurisdiction too. And Nicole, we can add any of those items now. So a lawsuit can be filed to stop any violation or threaten violation of the act, to determine the applicability of the act to actions or threaten future actions of the legislative body, to determine the validity of any legislative body's action that discourages the expression of any of its members, and to compel the recording of a legislative body's closed sessions, which may subsequently be reviewed and released by a court in a future enforcement case. Move on. So if the district attorney, when receiving a complaint, investigates and decides that criminal action is warranted, and it is found by a court that there has been a criminal violation, each member of the legislative body who attends a meeting of that legislative body is guilty of a misdemeanor where action is taken in violation of any provision of the Brown Act, and the member intends to deprive the public of information to which the member knows or has reason to know the public is entitled. So that has to be proven in court. Criminal violations, typically you have to have an intent to commit the crime. And so the district attorney would have to prove that against each member that criminal action is taken up. And we can move on to the next slide. We're going to go over inadvertent error. And so for civil actions or for non-intentional, we'll call them errors or boo-boos, those acts can be cured or fixed. And so typically if the public notices that perhaps there's been an inadvertent error or an error that it's unclear if it's intentional or not, they can ask for a cure or to correct those errors. And the request for cure and the actual cure itself, that would not be admissible as evidence in a civil or criminal action, because we want to encourage boards and the public to work together to cure and fix any Brown Act violations. And so typically when there is a perceived or real Brown Act violation, the public and the legislative body, they should work together to, one, request cure and correct for demands, and then two, the board should attempt to cure or cure, and those back and forth communications and negotiations, those will not come in as evidence of any civil or criminal action, because we want to encourage transparency, and we want to encourage the public and legislative bodies to do their best to adhere to the Brown Act, which is complicated. And so this is the forum in which it's a safe area in which to cure and correct boo-boos. And so we will go on to the next slide. So this is where we can do, I can take any questions right now. We have a little bit of a limited time period on questions, but I'm hopeful that I can answer anyone's questions on any of the Brown Act materials that we've gone over today.
Okay, looks like Steve Maines has a question, so I'm going to lower his hand and I'm going to unmute him. Okay, so Steve, you're unmuted.
Well, thank you. I have a couple questions. My last time I went through a Brown Act was like 20 years ago in a much bigger operation in Southern California. We used to have workshop meetings. Is that under the special meeting, or is that that's no longer kosher?
So I did go over that. That's under, so workshops or trainings or seminars, legislative bodies can do all of those things, but you would have to post an agenda or, post notice of that, and the public would be invited. And so that can and does happen, yes.
Okay, I'm specifically thinking, I'm with Grenada Irrigation. We have no staff. To be a board member means you have a weed whacker and a flamethrower to clean ditches. Literally, that's how I got there. I was thinking I had wanted to review construction design, which was going to be a couple hours. I suggested just a separate workshop, and they didn't think that was possible. So you're telling me that this could be considered a training and we could do that? Again, full public.
Yes, so you can have community events, trainings, and workshops. It's just that because that is considered a meeting, if there's a quorum of the board at those events, that would be open to the public and it would be noticed. And so if you do want to or would like to plan such an event, I'm available to assist you in making those events compliant with the Brown Act. And we can talk about that together. You can call my office and we can go over how that would happen under the Brown Act. But yes, you can have those types of seminars, trainings, or community events where everyone gets together with a weed whacker and cleans up a field, or you can do events like that. You can have site visits. There's all kinds of flexibility within the Brown Act. It's just that the public is invited to participate and know about it. And so you would still need to follow the notice and agenda rules for that, but that can happen.
Okay. This is going to sound kind of odd. I don't know where everybody else is from. We had a major pipeline blowout last year, and we were out there fixing it and making decisions to spend money on the repairs at the construction site.
So for district specific questions like this, because we're not attorney-client privileged right now, Steve, I think that question may be better if we talk about that on the phone, or if we have a meeting about that.
Okay, thank you. One last thing on time limits for public comments.
So that is up to the board. Typically, we see agencies have a range of limitations. 3 to 5 minutes is very usual. You would put that in your agenda, that have a set time period that the board decides is reasonable. You can obviously make exceptions if there's a subject matter that's of great interest, but you would want to set those time limits ahead of time so the public is aware when preparing their comments and preparing to share their thoughts or criticisms or positive comments with the board members ahead of time. And so that can be at the beginning of the meeting, put in the agenda, or in a special meeting agenda.
Okay, thank you very much.
You're welcome.
Okay, anybody else have questions for Dana before she moves on to the conflict of interest code? Okay, I don't see any hands, so I'm just going to change our little slideshow here.